Hello, everyone, and welcome to our program, Redefining Agency Power, the Impact of the Supreme Court's Decisions in Jharkhasi, Loper Bright, and Corner Post. I'm Jeremy Marwell, and I co-lead Vini's Appellate and Supreme Court Practice Group. We're here today to discuss three blockbuster decisions issued at the very end of the Supreme Court's term that have cross-cutting significance for the federal administrative state and the regulatory programs that touch virtually every business and person in America. These cases are just the latest chapter in the Supreme Court's ongoing realignment of the separation of powers. I'm pleased to be joined today by several of my partners who will share their perspective on how these cases will affect key areas of law. We have Sean Becker on employment, Rebecca Fike on securities, Kathy Packenham on tax, Bill Sherman for energy, and Ron Tempest on environment. Our discussion today will address three key cases: Loper Bright v. Raimondo, where the Supreme Court overruled Chevron deference and redefined the way that federal courts review agency interpretations of statutes that they administer; Corner Post v. Board of Governors, which held that a claim accrues for purposes of the 6-year statute of limitations for claims against the United States when the plaintiff has a complete cause of action in the sense of being injured by the rule. That sounds like a very technical issue, but in practice, it means that there is a much longer time in which you can challenge rules and regulations, including rules and regulations that might have been promulgated years ago. And then finally, SEC v. Jharkhasi, which held that the Seventh Amendment guarantees a defendant a jury trial in an Article III court when an agency seeks civil penalties against him for securities fraud, significantly cutting back the use of agency in-house courts. The United States was on the losing side of all three of these cases, which were decided by the same 6-3 majority, and 2 of the 3 opinions were written by the Chief Justice. If we could go to the next slide, please. We chose these 3 because of their cross-cutting significance for our firm's client base, and because we've gotten just a flood of questions about what they mean, what these 3 decisions mean in practical terms for a wide range of areas, including those that we'll cover today: energy, environment, tax, securities, and employment labor. And also, the 3 cases interact in what we think are important ways. Corner Post's lengthening of the statute of limitations for challenging agency rules is kind of a 1-2 punch, heightening the practical impact of Loper Bright's elimination of deference to agency interpretations. And that's going to have meaningful impacts up front in the rulemaking process. And then Jharkhasi, kind of at the back end, at the point of enforcement, is a meaningful constraint on agencies' ability to adjudicate penalty claims and other claims in their own in-house courts. If we go to the next slide, please. So we have our first polling question, which should pop up for you in the chat. What agency is most important to you in terms of the regulatory authority and the impact of these decisions on you or your company or your clients? We have several options, including an other, if we didn't capture the ones that are most important to you. We'll keep moving, but you'll have a few minutes to answer this poll question on your screen. Next slide, please. One more, thanks. So we're going to go very briefly over the basics of what happened in Loper Bright, and then turn to the practical implications, including in 2 specific areas: environment and employment labor. So the case involved the landmark decision Chevron v. NRDC from 1984, which established a very famous, now infamous framework for how federal courts review agency interpretations of the statutes they administer. Famously, at step 1, the court asks whether Congress spoke directly to the issue. If so, the court gives effect to the meaning of the statute without regard to what the agency says. But at step 2, if the court thinks the statute is silent or ambiguous, then the court is required to defer to what the agency's reading is, so long as that reading is reasonable. And critically, even if the court would have chosen a different reading. And that's really where all the action was. So why does it matter? I mean, it sounds like a sort of technical, lawyerly type question. So mainly because it provides a significant thumb on the scale in favor of the government in challenges to agency action. All the government has to do is be reasonable. It doesn't have to have the best reading of the statute. And this doctrine has been used to to support expansive conceptions of federal regulatory authority using perhaps older statutes or general statutes or vague statutes to support new regulatory programs, even if the statutes in question really weren't intended or didn't specifically speak to a question. And we can't ignore the reliance interests. By one count, Chevron has been cited 18,000 times since 1984. That's a lot of cases. And overruling Chevron is a natural question. What does it mean for all of those cases? If we could go to the next slide, please. So what did the court hold? Very clearly, Chevron is overruled. Courts have to exercise their own independent judgment in deciding whether the agency has acted within its statutory authority. They shouldn't and cannot defer to the agency just because a statute is ambiguous. So that's essentially eliminating the Chevron framework. But, and there's always a but, the court emphasized that nonetheless, the agency or the executive branch's interpretation may be important, may help inform what the court does. And the court identified in Loper certain circumstances where courts still will respect a specific delegation of authority to an agency, creating sort of a zone of discretion. And I think there's a fair question in those cases, that subset of cases, how different will that kind of review be from the old-fashioned Chevron review? Next slide, please. Very briefly, what did the majority rely on? Why did they overrule Chevron? Two main points. First, and I think primarily, the Administrative Procedure Act, which is a longstanding federal statute that governs judicial review of agency action and sets forth administrative procedures. And it says that courts, quote, shall decide all relevant questions of law. And in the majority's view, that was inconsistent with a regime where courts don't decide the question, but rather defer to the agency and adopt the agency's reading. And the court also, and for at least one justice, this was very important, went to sort of Civics 101, Article 3 of the Constitution, and the famous words of Marbury versus Madison. It's the province and duty of the judicial department to say what the law is, and the meaning of a statute is a question of law in their view. Next slide, please. There was a very sharp dissent by Justice Kagan, joined by Justices Sotomayor and Jackson. In their view, Chevron was correct. This is what Congress would have wanted. It knows that because of the limits of language and foresight, Congress can't write perfect statutes. They can't anticipate everything that may occur. And they would want the politically accountable, expert, technical, experienced agencies to fill in the gaps, not courts. And for the dissenters, stare decisis was a major concern, what they called a massive shock to the legal system of overruling this kind of foundational precedent. Next slide, please. So what does this actually mean, right? There's a lot of words, but what does it mean? The headline point, I think, is important, that going forward, in most cases, even when they involve an agency in a federal statute, courts will do what they have always done in cases that didn't involve agencies. The courts will make their own judgment about the best meaning of a statute using what we call the traditional tools of statutory construction: text, context, structure, purpose, history. And they will land on the single best reading. The majority was clear that they thought there was such a thing in every case. But there are some areas where I think we will see continuity, and that goes to the point that I made at the beginning, that there's sort of always a but. The court emphasized that in some cases, an agency's interpretation will be particularly persuasive if it was adopted contemporaneously with the statute's enactment, and it was long-standing rather than a reading that has flip-flopped. And the court identified, if you look in footnotes 5 and 6 of the decision, certain areas where an agency will continue to get, I think, a form of deference. So one example, and it's often helpful to talk about specific examples, is a statute that gives the Nuclear Regulatory Commission authority to regulate substantial safety hazards, and these are the key words, as defined by regulations which the Nuclear Regulatory Commission shall promulgate. And the court emphasized that that's an express conference of discretion to an agency. There are other categories, like when Congress uses terms that by their nature are discretionary, like an agency can do appropriate things or reasonable things. Next slide, please. And so here, the court is going to play a meaningful role. It's going to address whether the delegation is constitutional. It's going to say what the boundaries of that delegation are. So a rule addressing safety hazards, probably shouldn't be based on environmental concerns because environment is different than safety. But then at the end, it will just make sure that the agency has engaged in reasoned decision making within the boundaries. So has the agency given a reasonable explanation? Has it considered the right factors? And that's the part where I think an agency is still going to get certain deference. Next slide, please. But there are meaningful differences. I think overall, we should expect federal agencies to have a lower batting average, so to speak, in cases where the meaning of a statute is at issue, particularly where a statute is unclear. I think it's going to be harder for agencies to use old or vague or general statutes to justify expansive new programs, but you might reasonably point out that it's already sort of hard for agencies to do that. The court has cut back on Chevron in previous cases, including under the so-called major questions doctrine. And it will be harder for agencies to change their views with the change of an administration, because now a court will say there's a single best reading of a statute under Chevron. An agency had an ability to change its reading with changes in administration that will be much more significantly limited. And I think we really have to watch carefully about efforts to revisit the thousands and thousands of past decisions that applied Chevron to uphold agency action. The Supreme Court majority was clear that they didn't view this decision as automatically undermining all of those cases, that they would still be entitled to what's called stare decisis. And you would need to say more than just, well, Chevron's been overruled, so now those cases are revisited. That was clear. The majority did not view it that way. But there is a window, an opening to potentially challenge these old decisions. And I think when we get to the corner post portion of this discussion, that may be an interesting overlap. So let's try to turn to a specific practice area. It's always easier to talk about these things in specific terms. And I'd like to bring Ron Tempest in to talk about environment. Ron, I don't think it's a coincidence that so many of the key precedents in this area were environmental cases, and Chevron itself was a Clean Air Act case. So what are you seeing in terms of Loper-Bright's implications for environmental law and folks who are regulated in that area by EPA and other agencies?
So why don't we go ahead a slide. Before getting into, I guess go one more. Before getting into some detailed examples in environmental, I pick up on two things, Jeremy, you had to say that are sort of larger, big picture observations. I think the first is that, Chevron for critics of Chevron, I think in particular, it was often viewed as a mechanism to expansion of regulation, that because it granted deference to regulatory agencies, and if you have the view that what does a regulatory agency tend to do? It wants to regulate and extend and expand regulation, that Chevron sort of built in a bias towards the direction of more regulation, more complicated regulation. But I do want to start by picking up on the point Jeremy noted in environmental as one example. One of the things that often happens when you have an election is a new administration comes in, and as to regulations that may have been adopted previously, they want to unwind those in some fashion or another. Shorthand is often people talk about rollback efforts. And so I do think that one, thing particularly worth noting, because we are in an election season and there is at least some possibility of a new administration, there is a way in which getting rid of Chevron makes that harder, because it does really say the courts are the bottom line in what a regulation requires or prohibits. And you can imagine worlds where an attempt to repeal or limit a regulation, that itself can be subject to challenge in the courts, and a robust, active court might say, no, I get to read the language now and you can't roll that back. So there is, I'd say that is one big picture observation. The second is, again, to pick up on your point, the majority said, is very clear in saying this stare decisis considerations will not now allow every decision that was ever decided relying on Chevron to be attacked. But there is, potentially a workaround as to that I think people will explore, which is, what if a challenge happened in the Ninth Circuit on a regulation, and the Ninth Circuit affirmed based on Chevron principles, and the case never made it to the Supreme Court? Well, I think people will be looking for ways to get that question into the second or the sixth or the first, where the thought will be, you now get a fresh reading by the court on its view of the statute without any obligation to defer. And so I think in environmental, this is an area where people will be looking for those kinds of things. Now, jumping down a little bit more into three kind of specific areas and building off Jeremy, I think the way I've been thinking about this is there's sort of three buckets to think about that are two on the extremes, which I think maybe are the easiest cases, and then one sort of in the middle. So you've got, I think, statutes, and I guess I should start. The impact of Chevron here in environmental is very particular to statutory language. So you need to think about these questions in the context of the particular statute or regulation that you're considering. So you get, I think, places where it seems to me pretty clear the language of the statute sort of calls for a legal interpretation. And I've given you a couple examples. Your mileage may vary about whether you think these are truly all legal, and I've given you kind of three cases where these kind of rules are being challenged right now. One is what's called the small refinery exemption on renewable fuels. That's being litigated right now. The idea is that small refineries should be relieved of some renewable fuels mandates that otherwise exist if they would suffer disproportionate economic hardship. I think that language sort of feels to me pretty like a legal term that a court will say, we know what the word hardship means, we know what the word economic means. Disproportionate, maybe that's a little bit more in the wind, but we are perfectly capable of judging those words and how far they should extend. Another example, there is a major case going on in the DC Circuit on a recently promulgated rule that applies, basically in shorthand to power plants, particularly to natural gas and coal-fired power plants, and where one of the concerns about the rule from challengers is it seems to call for or require using carbon capture and sequestration. The regulatory or the statutory language allows the EPA to promulgate rules and demand technologies that have been adequately demonstrated. And one of the big arguments there is, well, has CCS really been demonstrated at any large power plant, much less adequately demonstrated, does adequately demonstrated one prototype test plant or 20 or 100? Is cost effectiveness a part of that? So again, kind of an example of an ongoing case where to me, it feels like probably kind of a legalish determination. And then there's been an ongoing saga under the Clean Water Act for now 20 plus years about the meaning of waters of the United States, which defines EPA and the Army Corps' jurisdiction to regulate, allow fill of waters, is what gives EPA the power to set discharge limits. Those all have to be effects on waters of the United States. Again, that feels to me like a kind of legal term of art where a court is probably going to be pretty robust. Let's move ahead. On the other end, I think, as Jeremy mentioned, there are statutes that very expressly use words like discretion or judgment. So as determined by the discretion of the administrator or the judgment of the administrator, show you, one of the most extreme kind of formulations, safe drinking water, the sole judgment of the administrator. In those places, I think it's pretty hard for a court to come in and say, you made the wrong judgment. There may be separate questions about, can Congress extend that much power to the executive branch, what are called anti-delegation principles and things, but that's sort of a separate conversation, different day. But in terms of how much the court gets to second guess a judgment, I think that's going to be, even with Chevron not in place, that's going to be a tough place for courts to go. And let's go to the third. Then there's, I think, what's the middle case, where you've got some combination of technical and scientific judgment involved, but arguably a kind of legal determination in play. So take the first one there, Toxic Substances Control Act, which has to do with chemical regulation. There's the ability to regulate as to chemicals that present an unreasonable risk of injury to health or the environment. Okay, so the first question you've got is there some reason to think this chemical injures health? And say the evidence is there have been 7 studies on a certain chemical, 2 of them kind of suggest no injury, 5 suggest maybe it can be injurious, and the agency decides, you know what, it's not a matter of just 5 to 2. We think the 2 are better studies, and thus we don't think there's a risk of injury, to health right now. Decides not to regulate. That, how much credit and which is the best study feels to me like the kind of thing where courts, even if you read the Chief Justice Roberts' opinion, I think there's a suggestion of that's the kind of thing courts shouldn't second guess executive branch agencies. But then think about, okay, there's some finding of injury to health, but then it has to be an unreasonable risk. Okay, how much risk is unreasonable? That maybe feels like more of a legal judgment. Is, a 1 in 1,000 chance that somebody has a higher risk of cancer, an unreasonable risk? Well, what's the cost if we get rid of this chemical in the economy? So I think it's these ones that are in the middle that feel like a combination of technical and scientific and legal, where we're going to see a lot of fighting, and where a lot of the lawsuit arguments are going to be briefs over that ground. And how do you draw that line? So I think that kind of summarizes where I think, big picture, this all is likely to fall.
Thanks, Ron. That's super helpful, and I think a through line here is context matters that we'll probably continue to hear. Let's shift to employment, and if any of you have been following the Westlaw updates, so to speak, Loper Bright has already been cited in several decisions in just the past 10 days or so, some of which implicate kind of labor and employment law. So let's turn to Sean Becker for his views on how Loper Bright may impact that area of law immediately and over the long term.
Thanks, Jeremy. The employment relationship is governed by many, many statutes, and therefore there are many implementing regulations, and the regulations, the rules, the standards applied by agencies oftentimes will shift administration to administration. So Loper Bright's going to present some interesting developments. We're already seeing, as Jeremy said, some cases in the employment context citing Loper Bright. And I do think that there's going to be more activity in light of this precedent. Perhaps the most high-profile area that employers have been watching lately is the FTC's rule banning non-competes. As you likely have read, likely have heard, the FTC came out with a rule scheduled to take effect on September 4th that essentially bans all non-competes. It does have a couple of exceptions that allows for sale of business-related non-competes and would allow for the preservation of legacy non-competes with senior executives, so people making above a little over $151,000 and in a policy-making position. But otherwise, it is an expansive proposed ban. Not long after the rule was announced, the litigation ensued, and the leading litigation has been the case in the Northern District of Texas in Dallas, the Ryan LLC versus the FTC case. The U.S. Chamber of Commerce, Texas Association of Business, among others, have joined that case as plaintiff interveners. And at issue in that case very much is the scope of authority granted to the FTC under the 1914 FTC Act. Section 5 of the FTC Act provides that the Commission is empowered to direct and prevent persons from using unfair methods of competition and unfair or deceptive acts or practices, in each case affecting commerce. In turn, Section 6G of that statute gives the FTC the power to make rules and regulations for the purpose of carrying out the provisions of the subchapter. So that's the statutory hook on which the FTC rests its arguments for having the authority to implement the non-compete ban. FTC Commissioner Khan, in her words, I think she said, non-competes keep wages low, suppress new ideas, and rob the American economy of dynamism. So therefore, that amounts to unfair competition. And given it's then she can go forward and the Commission can go forward to ban non-competes through the power granted in Section 6G. Not surprisingly, Chamber of Commerce and the plaintiffs in this case, Ryan LLC is a tax service, a tax preparation, tax advice service, says, no, that's not the case. You have overreached. The statutory grant was not that broad. And in an opinion that was issued on the afternoon of July 3rd, right before the long weekend, Judge Brown in the Northern District of Texas issued an injunction. Right now, it's an injunction that applies only with respect to the named plaintiffs in that case. And so it's not a nationwide injunction. But her injunction sided with the plaintiffs and says, no, that's right. The statutory delegation here does not go as far as the FTC claimed. And the case, it relies on many grounds, but does cite Loper-Bright. And in doing so, the analysis, it's very much a textual analysis of the statute. And then the court does say, looking at history, that when a statute doesn't include a sanction, then the authority to make rules and regulations that's then granted to the agency encompasses only interpretive or procedural rules. And so therefore, in the court's holding that Section 6G, it's a housekeeping statute. It allows for implementation of rules of agency organization or procedure, but not substantive rules. Notably, the court also looked at the history of the statute. I mean, looking since 1914, there were significant amendments in 1975 in the Magnuson-Moss Act. In those amendments, the FTC was given the authority to make substantive rules with respect to unfair or deceptive acts or practices, but the court emphasized not unfair methods of competition. So the non-compete rule overreached in the court's opinion. Again, I don't want to oversell the importance of Loper-Bright here because the court held that, in its opinion, the rule was also arbitrary and capricious. The one-size-fits-all approach taken by the rule was too broad and not justified by the underlying fact-finding. But again, Loper-Bright is part of the foundation on which this opinion is based, and I think it's notable. And I think we very well might see that again there's another challenge to the FTC rule in a case brought by a tree service that will be interesting to see how that comes out in the next few weeks and whether that relies on Loper-Bright. If we could please go to the next slide. Some other areas, and again, one very recent example of where we're seeing Loper-Bright and how it's affecting agency rulemaking, we get to the Department of Labor. And the Department of Labor has authority for, among other things, implementing regulations with respect to wage and hour law and the Federal Fair Labor Standards Act. The FLSA is a 1938 statute. It provides that any employee in a bona fide executive, administrative, or professional capacity is exempt from the overtime requirements of that law, so you don't need to pay overtime. The DOL regulations have for a long time, as likely most people on this webinar are familiar, has a couple of tests. One, there is the duties test. Does the day-to-day duties of a particular employee satisfy executive, administrative, or professional qualities? And then the second test is the salary test. Is there a particular salary provided to the individuals that's guaranteed on a weekly basis? And since 1940 or so, there has been a salary element to determining whether or not these exemptions are satisfied. I think in 1940, the minimum weekly salary requirement was $30. So we've come a long way, but it's been there for a while. In 1966, the Fifth Circuit looked at the challenge of the FLSA and did say that yes, it is permissible to require a salary prong as part of the tests. But then there have been some notable challenges. First, in 2023 precedent, that actually challenged the Trump era DOL's increase to the salary threshold that employees needed to satisfy to be subject to one of these exemptions. That increase did take the salary from $455 minimum per week to $684 per week. That gets challenged, and in an opinion in September of 2023, Western District of Texas squarely cites Chevron and says, I have to defer to the agency interpretation, and Chevron deference results in the challenge being unsuccessful. That case is now up on the Fifth Circuit. It's scheduled for oral argument on August 5th. It will be very interesting to hear what happens with those arguments in light of Loper Bright and to see what happens if and when that case is remanded post Loper Bright. Meanwhile, there's another challenge to a different salary regulation from the DOL. So the Biden era DOL, so one-upped the Trump era DOL regulations and said, we're actually going to further increase the minimum salary threshold to $844 per week. And it's going to increase from there as of January 1st, 2025. The minimum is going to be $1,128 per week. And then there's going to be step-ups, cost of living adjustments every 3 years. That regulation was then challenged in the Eastern District of Texas, and the same day that Loper Bright is issued, court comes out, issues its injunction. Now, it's an injunction that applied only with respect to the state of Texas as an employer in that case. But the court says that we are going to hew to Loper Bright standards. We don't have to defer under Chevron, and we're going to look at the plain language. And plain language of the statute says any employee in an executive, administrative, or professional capacity. It doesn't say anything about any employee making a certain threshold. So one, we think that the statutory delegation does not allow for these significant increases by its plain language. And two, let's go back and look at what the word capacity meant back in 1938 when the FLSA was implemented. So employees in a bona fide executive, administrative, or professional capacity are those who are exempt. And the court cites from the 1934 edition of Webster's Dictionary. So legal history, used booksellers are all going to be come back and be very important here as we look to the context, or what the court wants to determine was the context. So in that instance, the court notes also that because the new changes would impose sweeping rules, maybe it's because they're simply too broad, they go so far, and maybe that's a way to reconcile the 1966 Fifth Circuit precedent that maybe there can be a salary basis. But the court in that instance says, look, this rule goes so far, goes too far, that it makes the salary test the predominant test as opposed to the duties test. And it's the duties that are mentioned in the capacity that's mentioned in the statute itself. So quickly, just going to the next slide, please. If we look at just some other areas where we can see potential rules coming to be challenged. Again, there are a lot of ripe areas. Now, many employment statutes do in fact have delegations of authority to agencies to make interpretations, to consider definitions. But still, I think that areas to focus on, National Labor Relations Board. We're obviously going to see, to the extent that Chevron deference was granted, that now goes away. And so areas such as NLRB, guidance about which employers can be a joint employer and thus jointly responsible for labor law obligations. Under the 2020 rule issued by the NLRB, An entity could be a joint employer only if they exercise substantial and direct immediate control over certain elements of the employment relationship. Under proposed 2023 rule, that standard then shifts, and indirect or reserved control could be sufficient. So again, I think that necessarily, given that the shifting focus, that there's going to be more challenges and then more of an analysis of, well, wait a minute, what did the statute contemplate? Similarly, Section 7 of the statute, the National Labor Relations Act, protects protected concerted activity by employees, being able to act for each other's mutual benefit. More recent guidance and interpretations from the current NLRB and from its general counsel have said that, well, wait a minute, we think even non-competes, employee non-competes, could violate this standard. Does that go too far? Is that consistent with statutory words or the grant? EEOC, obviously we're seeing one area right now, Pregnant Workers Fairness Act, which actually is the statute says that accommodations are required for pregnancy, childbirth, or related medical conditions. Well, the court in Louisiana recently enjoined implementation of that to the extent that the EEOC's guidance said, well, we think that pregnancy, childbirth, or related medical conditions also requires accommodations for abortion-related access, abortion-related care. And so, that actually falls within the statute. The court said, no, you go too far. Again, in a post-Chevron world, I think you're going to see more examples like that of courts scrutinizing EEOC or agency determinations. Finally, OSHA. Similarly, OSHA is a very broad statute from 1970, says that there are requirements to maintain workplace health and safety standards, general duty to have a safe workplace. There is a fair amount of grant to OSHA to implement the regulations for what does that mean, but are we going to see more instances like we did post the COVID emergency temporary standard that OSHA issued in 2022? Now, in that instance, the court said, okay, OSHA, you have implemented vaccination, testing requirements for your workforces in the US. We think you've overreached. OSHA is a workplace safety statute. It's not a public health statute. Now, the court there was relying on major questions principles, but it's going to be a lot easier to get there now with Loper-Bright. So stay tuned. We will see, and we will see how courts are interpreting sort of their new or their expanded authority to interpret the statutes themselves.
Fantastic.
Jeremy, is it time for another question?
It is time for a polling question. Make sure people are awake. Have you ever been involved in a challenge to an agency rulemaking? This is an easy one. Yes or no? As before, we'll leave it up on the screen for you to answer. If we could advance the slide, and we will turn to Corner Post, and I'll invite Kathy to kick off this portion of the discussion.
Hi, good afternoon, everybody. Thanks, Jeremy. So I think Corner Post is actually the last decision of this most recent term of the Supreme Court. So it may not have gotten, I think, the attention that it deserves in the overshadowed by Loper-Bright, which of course, as our panels have talked about, has incredible implications. But I think that Corner Post is going to turn out to be the sleeper decision out of this term as it relates to administrative issues. So Corner Post is a truck stop in North Dakota. The case is actually pretty easy to describe. So I'll walk you through what the court decided. I'll touch on some of the Treasury regulation implications, and Jeremy described it perfectly before. Loper-Bright and Corner Post are really a 1-2 punch. And so I'll talk about those two things as they relate to one another for Treasury regulations, and then we'll talk some about how all of this plays out in the EPA context. So let's go to the next slide. So the case, it's actually a really great litigating vehicle. It's set up this particular issue perfectly. And the question is, what is the statute of limitations in which a claim that a regulation is invalid must be brought? So this particular dispute, it's not really all that relevant, but the issue was a Federal Reserve Board regulation that set a maximum fee that could be charged on the use of debit cards. And that regulation was issued in 2011. Now, our plaintiff here, Corner Post, the truck stop in North Dakota, was incorporated in 2017, and it began doing business in 2018. So it first started paying over these debit card fees in 2018. It brought suit in 2021 against the board, claiming that this regulation was invalid because it charged a fee that was higher than the fee that would be permitted by statute. This case was in district court in North Dakota. The board brought a motion to dismiss, which was granted. The court said, nope, statute of limitations is 6 years. That 6 years started running when this regulation was promulgated in 2011. Your suit, Corner Post, brought in 2021 is too late. The case was appealed to the U.S. Court of Appeals for the 8th Circuit. The 8th Circuit affirmed and concluded that the statute of limitations had long since expired. Next slide. So here's the particular statute that was at play here in Corner Post and underlies all APA statute of limitations issues. And it says that every civil suit brought against the United States is barred unless the complaint is filed within 6 years after the right of action first accrues. Looks simple on its face, not so simple in application. Next slide. So here's the question. When does a cause of action accrue for an action that is brought under the APA challenging the validity of a regulation? Next slide. So there was a circuit split, and this is how it ended up in the Supreme Court. The majority of circuits, including the 8th Circuit, concluded that the limitations period for facial APA challenges begins on the date of final agency action. Here, the date that the regulation is actually promulgated, regardless of when the plaintiff was injured. The 6th Circuit was an outlier here, and it had concluded in the Harrow versus U.S. Forest Service case that the Section 2401 statute begins to run when the statute is injured by final agency action, even if the injury did not occur until many years after the action became final. Next slide. So here's the decision in Corner Post. Again, like the decisions we're talking about today, all broke down 6-3, supermajority, consistent. This opinion is written by Justice Barrett on behalf of the court. And what the court concluded is that the claim accrues, this is basically what the 6th Circuit had held, that when the plaintiff has a complete and present cause of action. And so for APA cases, that's really two things. One, the plaintiff has suffered an injury, and of course, that's going to depend on the particular context. And second, that there has been final agency action. The court, in its opinion, differentiates between a statute of limitations like Section 2401 from a statute of repose. And I think Ron's going to talk a little bit about that in the EPA context in particular. A statute of repose puts an outer limit on the right to bring a civil action, and that's measured from the date of the last act of the defendant. Here, Corner Post only suffered an injury when it first had to pay over those debit card fees in 2018, and therefore the court concluded that the action accrued in 2018 and that the suit brought within 6 years, here it was brought in 2021, was timely. Didn't rule on the regulation itself, that is still to be determined, but the court concluded that it was still a live issue and could be litigated. Next slide. Seems pretty straightforward. Implications of Corner Post. There was a fiery dissent from Justice Jackson. I'm just going to read you the very first sentence of it, which I think kind of tees up the question. And what Justice Jackson wrote is the following. At the end of a momentous term, this much is clear. The tsunami of lawsuits against agencies that the court's holdings in this case and Loper Bright have authorized has the power to devastate the functioning of the federal government. Now, of course, it remains to be seen whether or not that is, in fact, what the outcome will be. But that is certainly, I think, the issue that we're squarely on the horns of now. Next slide. So I promise you I'm not going to talk in detail about a lot of complex tax regulations, but I want to highlight a few issues. And we'll do a separate webinar talking about, for all you tax nerds, tax lovers out there, we'll get more into the weeds on all of this. But I want to highlight a couple of key issues here that are likely to arise. And I'm going to pull out my crystal ball and make a couple of predictions. So the first thing I want to point out here is that traditionally there had really not been a lot of challenges to Treasury regulations. And why is that? I mean, there are literally thousands of tax regulations. Most of them are decades old. and they have been kind of widely accepted and not challenged. The first is the Tax Anti-Injunction Act, which prohibits injunctive action that interferes with the assessment or collection of federal taxes. That has been a bar historically to injunctive action in the tax area. The other is this concern that's actually raised by Corner Post, is that the government has argued that the 6-year statute bars challenges to old regulations. And then the third thing that's kind of also compounded this is this concept of tax exceptionalism that existed until the Mayo decision, which was that Treasury regulations are somehow special and that the IRS knows everything that there is to know about taxes. It's an incredibly complex area, and therefore the courts weren't going to challenge Treasury or the IRS's judgment. There's been really a movement away from that in the course of the last few years, and I think that really started with the CIC services case. I'm going to talk about that in 1 second. But I will say a couple of things. One is that the combination of Loper Bright and Corner Post may provide a very powerful avenue for challenges of regulations that had kind of widely been accepted in the tax community. It is going to be very important to distinguish between the types of regulations. We generally have 3 in the tax area. Legislative, that's where Congress says, Treasury, please go promulgate regulations to expand on this particular thing that's found in the Internal Revenue Code. Interpretive regulations, sometimes those are mentioned in the statute, but there's also this general grant of authority under Section 7805 that gives Treasury the ability to issue regulations. And the third bucket is procedural. And I think the implications of Loper Bright will be different. I will say for all of you out there that have a responsibility related to tax matters, what I would suggest is that you go back and look at tax returns where your statute of limitations to seek refunds that may be triggered by challenges to regulations. Go take a look at those. You probably have until September, October of this year to file refund claims as they relate to tax year 2020. Let me just leave you with one example and then a couple of observations about what I think comes next. Treasury Regulation 6011-4. This has to do with what the IRS would describe as tax shelters, but there are all of these definitional rules. It's a very old regulation. It was first promulgated in 2007. It was amended in 2010. It takes on additional importance every so often when additional transactions are identified as listed transactions or reportable transactions. It had long been believed that this regulation was too old to be challenged, even though there are a lot of, I think, issues with respect to whether it actually exceeds the authority that Treasury has to issue that regulation. But if this is a regulation that's challenged, there are all kinds of ripple effects down the road with respect to particular penalties, with respect to particular statutes of limitations. And this is one that I think is probably going to be one of the first ones that ends up getting challenged after the Loper Bright decision. But let me just give you a couple of reactions. One is, I think that the first impact that we will see in the tax area is that a real slowdown with respect to rulemaking and the issuance of regulations as Treasury figures out how to grapple with Loper Bright. There already have been all kinds of issues for Treasury because historically they had not followed APA rulemaking notice and comment. So for these old regulations that were not issued following notice and comment that it's now clear that they should have been, that may open up this tsunami that Justice Jackson talks about with respect to Treasury regulations. The other kind of tidbit that I thought was pretty interesting is we have a couple of tax court nominees that were testifying before Congress yesterday. They were each asked about their views with respect to Loper Bright and whether or not they were willing to, in fact, find Treasury regulations to be invalid. A clear signal from Congress as to what they expect the judges to do in response to these Supreme Court decisions. This is already a live issue in some cases. For those of you who are following the case Tribune, which is now pending before the 7th Circuit, there's already been some supplemental letters to the court. That case involves the validity of the anti-abuse regulations under subchapter K. So that may be one of the first decisions we actually see that talks about the implication of Loper Bright in the tax context. And so just one final takeaway, and then I'll turn it over to Ron, which is, the question for me is, does this lead ultimately to more tax litigation? A thing to keep in mind is that most tax cases settle, they settle at the administrative level, except that it's important to keep in mind that under IRS procedural rules, the IRS Office of Appeals will not take into account the validity of regulations as a basis to settle a case. So the only place really to resolve these kinds of challenges will almost never be by settlement on the administrative level. They're going to require litigation. So more to come. We'll do a separate tax-related webinar on this one. Let me turn it over to Ron.
Thanks, Kathy. So we can go to the next slide. I'm gonna do kind of a quick run through on environmental, and again, kind of put it in 3 buckets. So the first bucket has to do with whether corner post opens up the field to a lot of challenges to environmental regulations. And I think, Kathy did a great job of highlighting the fact that the court distinguished the APA, which says you get to sue once your claim accrues, versus a statute of repose, which says you get to sue only within a certain time period of the defendant's action. And so many of the rulemaking challenges, just bluntly, are going to be run into that statute of repose approach to things, at least in my view. We've just highlighted 4 here, for example, where you can see that what the review provision that's in the act, so that you can go in and challenge a new regulation, is explicit, that says you have to bring it within 60 or 100 days from the date of notice of such action appearing in the Federal Register. That's basically the date the regulation is formally printed in the Federal Register. So in my view, a lot of things that folks might think would be open to challenge and revisit as to very formal EPA issued regulations probably are going to run into the point that review of those regulations doesn't occur under the APA, it occurs under these other provisions that are in the act themselves, and which seem to read very much as the classic statute of repose kind of language. One quick footnote to that, as you can see, many of these say you have to do challenge within 60 days of publication, except if you have grounds arising after the 60th day. I would suspect there will be some litigants and folks who will want to think through, does corner post in some fashion give at least a little more vibrancy to the idea that you can say that your grounds arising after for challenging regulation is you as a company didn't exist on the date that the regulation was first promulgated. I will say that kind of theory has been tested previously in the courts, having to do with a reclamation statute, not these in particular, but where there was a kind of statute of repose type time limit. There's not a lot of litigation in this area, but in the places where a kind of similar claim has been tried, it has been rejected. But again, there are ways in which it just seems possible that corner posts will get people thinking about that issue again. Second bucket I want to talk about is one place where the APA is the vehicle to review very often is when typically a private company, although it can also be government constructed projects, has some kind of major construction or development project, a pipeline, a transmission line, it goes building facilities next to a port or harbor, where you're going through an environmental review, particularly pursuant to NEPA, because you need some federal permit to do it, a permit from the Army Corps of Engineers, a permit, as just one example, or you're building on federal land and going to construct something within the bounds of a forest. When litigants want to sue to block those, they sue the agency that's given that permission and frequently say, the reason this should be blocked is your environmental review was not sufficient under NEPA. That's arbitrary and capricious action. We can challenge it under the APA. I think my view, although I do think people may have competing views, is while maybe nominally Loper Bright opens up projects to now longer developed challenges beyond what you might think is the classic 6 years from the agency decision. As a practical matter, I'm not sure that's a huge real world problem to now imagine somebody comes along 8 years after permission to build a transmission line was given, particularly if that line is already fully constructed. There are practical issues of just courts being hesitant to think about, validating such a late arriving claim when you've invested significantly in infrastructure. There's the problem that this review is what we call record review, based on the record of the agency at the time. You might assume that if nobody felt comfortable challenging the big project at the time, in part that was because the record seemed pretty strong as to what the agency decided. And I'll note just one other thing. Usually to have standing, you need to be able to show that you can get some meaningful relief. And sometimes if the major environmental effect was going to happen during construction rather than during operation, you're going to be digging up some land or temporarily bothering a river during construction, but then once in operation, the environmental impacts are no longer meaningful. There are some of the late breaking challenges, trying to challenge 8-9 years down the road are going to be founder, I think, on, well, what's the meaningful relief you want? The construction has happened and the day-to-day operation is not actually causing environmental impact. So that's sort of how, at least preliminarily, I'm seeing it on the NEPA project review, and we can go to the next slide. Here's the place where I think it is going to matter. There are a variety of areas of environmental decision-making where the APA is your vehicle for review. They tend to be in the buckets of uses or regulations of operations on federal lands, and also then Endangered Species Act listings or habitat listings, which then impact what you can do commercially in nearby locations where that species may be found. Those challenges do arise under the APA. We've identified 3 of them that are pretty active right now, that are particularly significant, I would say, in the mining or in the energy arena, and where since the challenges are already ongoing, they don't need the benefit of Loper Bright, but these are the kind of rules that to me seem likely to be later challenged by virtue of Loper Bright. I'll note Kathy mentioned that part of the reason, or I'm sorry, I keep saying Loper Bright, Corner Post. Part of the reason that Corner Post was taken as a case by the Supreme Court was because of split in authority. That split came out of the Sixth Circuit having decided this Kerr case. And what was at issue there was the Forest Service put in some regulations that limited boating activity on a lake within a forest, but where there were lots of private landowners who had land adjacent to the lake. That rule was in place for a number of years. The Kerrs came along later, bought land, and were unhappy with the boating regulation and limitation, and thus went ahead and challenged more than 6 years after that regulation went in place. So again, it's both, to Jeremy's point, environmental seems to be the source of things, but that's the kind of place where you can see it coming up. So Jeremy, do we have another poll now?
We do, Ron. It's the next slide. Do you want to tee it up?
Well, you can see it all here. This is a pivot to jarcossy, our last case, which involves administrative enforcement. again, we're just inviting people to weigh in. Maybe if we have time at the end, we'll report back a little bit on where the numbers fell on this question and others. So why don't we move along while people are looking at that? We're now going to pivot to the case of Jarkissi. Jarkissi decided in again, right at the end of the term, but it is a story that actually begins almost 250 years ago. Let's go to the next slide. It's July 11th, July 4th was the issuance of the Declaration of Independence, and that's where our story begins. The Declaration of Independence was essentially a charging document against the king by the Continental Congress, laying out all of the things that had so motivated the colonists to break off. Contains the great word depredations, which I would use, and usurpations, which I would use more often if I could pronounce it. But one of the things they laid out was the complaint that the benefits of trial by jury have been restricted. Fast forward ahead to the Constitution being adopted about 12 years later. We can so strongly felt was this commitment to being able to have your day in front of a jury that that right was enumerated as a specific amendment in the Constitution in the 7th Amendment. And you can see the language here: in suits of common law, the right to jury trial shall be preserved. So now we can jump ahead to the next slide. Jump ahead, 150 or so years to roughly the last 100 years. You have the emergence of a new kind of entity within the federal government, the administrative agency, where, beginning in sort of the progressive era, early 1900s, and then through the rest of the century, you had new agencies being created and being given power by Congress to write regulations and to enforce them. And so where we have gotten to currently is we have a collection of administrative law judges at federal agencies. Notwithstanding the word judge, we should all just be clear. These are employees of the agency. There are efforts to keep them insulated to some degree from others in the agency, but they are not. They are ultimately employees of those agencies. You got about 2,000 total across all federal agencies. Admittedly, the Social Security Administration has a disproportionate percentage of them resolving things like workers' comp and other claims. But you also have the equivalent of judges at a variety of federal agencies running by different names. But these are the folks who are hearing these administrative penalty cases. We've shown you a few there. Just for context, since part of this is a fight about can these cases go to administrative law judges or do they have to go to federal trial court judges? There are 663 authorized federal court district judgeships in the country. So that gives you some sense of scaling as to how large this practice is within the administration versus kind of the actual federal trial court judgeship bench. Let's move ahead. Part of why this is a big deal, in addition to how many agencies there are, the dissent noted there are at least 22. That certainly undercounts these proceedings. What's at stake here is, in the administrative context, you don't have a lot of the things that you and I would associate as being involved in a trial. Even if you're just somebody who watches Law and Order, the rules of evidence don't formally apply. Hearsay is typically allowed. The right to discovery for those who are involved in civil litigation, often much more limited. Do you get to take depositions of the other side in advance? Sometimes, not always. So it's those kinds of procedures and protections that are at stake, as well as the point that at the end, the entity that's going to judge your case one way or another is a jury of kind of fellow citizens versus the administrative law judge who's an employee of the agency. So that's how we got here. That's what's at stake. We can go ahead. And that brings us to Jarkissi. What the court held in Jarkissi was a case in which the Securities Exchange Commission had brought an administrative case against Mr. Jarkissi, claiming that he had engaged in different kinds of securities fraud. and they proceeded through that administrative agency before an SEC administrative law judge and imposed a penalty. That was challenged and as a violation of the Seventh Amendment right to a jury trial, and the court concluded that the challenge was correct and that Mr. Jarkissi was entitled to a jury trial in a federal court. In the analysis kind of breaks down into two steps. The first thing they say, question to ask is, does the action, meaning essentially the lawsuit or the charge, implicate the Seventh Amendment? And they answered the question yes, as to the SEC claims, citing two reasons. First, they focused on the remedy that the SEC was seeking and basically said they are seeking penalties, i.e. not just that people be repaid any loss from fraud, but to penalize, punish, deter, make it cost more for the defendant than anything they got out of it. And cited a variety of factors to demonstrate that, and said the fact that the remedy is a penalty is all but dispositive. They then went on and looked at a second factor and pointed out that the SEC action was based on claims that statutory prohibitions against fraud were the basis of the claim by the SEC. And they pointed out that these statutory provisions replicate a common law action, basically common law lawsuits that have long existed against fraud. And they cited that as a second factor. So that's step one. That if you can sort of get past that, then you are, maybe the way to think of it is presumptively entitled to a federal district court jury trial as your venue. But they did acknowledge there has been lurking in the Supreme Court jurisprudence something called the public rights exception to this. And they, the SEC claimed, well, this was a kind of case that involved public rights. The court said no, even though the place where these violations are based is in statutory text. I will just say the public rights description is long, painstaking on both the majority and the dissent, so I will not try to summarize that. I think a lot of commentators still will feel that it's very difficult to discern what are the contours, and frankly, if much at all remains of this public rights exception. The majority used some very strong and repeated language about public rights being an exception, not the rule. And a lot of the discussion focused around a case called Atlas Roofing, which was a case from 1977 where the administrative proceedings were used to impose OSHA violations, and the court had Supreme Court concluded that was okay because that involved public rights. So, you know, I think the questions to ponder at this point, first is as to step one, there is a tone and tenor, I think, to the majority opinion that while they said all, but, you know, if it involves a penalty, that's all but dispositive, that may actually mean dispositive, even without finding an analog to a common law cause of action that's long existent. And then step two, what remains of the public rights exception, you know, not going to go into detail for environmental on this, but for example, there will be people now, I think, very quickly looking about for long-standing common law causes of action that go back, you know, decades and hundreds of years to try to find analogs. And if you can find a kind of common law analog, you're probably in pretty good shape. And so for environmental, for example, a lot of people are thinking about you have traditional suits for creating nuisances of air and noxious fumes, you know, in olden days. That might sound an awful lot like a Clean Air Act violation. And so I think those are the big things that are open going forward. I'm going to turn it over at that point. You can go to the next slide. And I think we're going to now focus specifically on what this means. It was an SEC decision, and we're going to focus now exactly on, well, what does this mean for the SEC?
All right, thank you, Ron. Hi, everyone. My name is Rebecca Fike, and we thought we'd start with impacts on the SEC since this was actually an SEC case, an SEC decision. But as you'll see, I think there's actually quite a bit more to say about other agencies than how it might affect the SEC itself. First of all, I think it's important to realize that Jarczy was initiated at the SEC fairly soon after the Dodd-Frank Act was passed, which allowed for these administrative courts to litigate contested fraud claims. Within a couple of years, the SEC's internal policies and procedures really no longer allowed staff attorneys to bring contested fraud, like substantive litigated matters in administrative proceedings because the challenges arose to these forums so quickly. So while Jarczy now officially means the SEC cannot institute a contested fraud charge in an administrative proceeding, practically speaking, they haven't for at least the last 10 years. So there's very few, if any, open ongoing cases that are going to be affected by Jarczy within the SEC itself. Now, what it does affect, or what it could potentially affect, is how the SEC brings certain other claims that they do currently bring in administrative proceedings. So currently, you might see in an AP, there are certain remedies that the SEC has that it can seek, that it has to do so in an administrative forum. For example, a Section 102E bar, which bars attorneys, accountants, engineers, other professionals from practicing before the commission. To the extent a 102E bar is going to be part of a remedy sought by the SEC, that has to be sought in an administrative proceeding. So I imagine we'll still see, plenty of those, but now instituted completely separately from any sort of other substantive claims that will now be filed for sure in federal district court. The Jarczy case seems to make clear, at least just on a clear reading of it, that the two triggers that mean the right to a jury trial comes up and that the action must be filed in federal district court is both the contested kind of common law fraud charge, as well as the request for civil monetary penalties. It seems like disgorgement is not going to be in that category. So if the SEC is simply seeking the ill-gotten gains that a defendant allegedly got, that is not what's going to trigger that right to jury trial. However, currently the SEC pretty much always seeks civil penalties, and the court held that those are punitive by nature and thus do require that jury trial. Where APs are currently used by far the most for the SEC is in settlements. So almost always a defendant in an SEC investigation who has decided to settle, whether or not they agree with what the SEC is saying or not, they made a business decision, we want to settle this, you almost always opt for the route of an administrative proceeding. And it's because the settlement is both initiated and approved at the same time. So because it is that internal group. So when the staff attorney brings the case to get authority to charge, they also recommend the settlement and the commission approves both at the same time. So the administrative proceeding is filed along with the offer of settlement. And as a defendant, you usually want that because you no longer have any, question of whether or not the settlement is going to be approved in the manner in which you think it will be. You often get input on the wording of the order. You don't have any doubt or risk that a judge might look at the settlement and say, actually, I don't approve this. Oftentimes, administrative proceedings are seen as sort of a less severe forum. It's, can sometimes be a distinction without a difference, but there's something in saying, hey, it was an administrative proceeding that we, settled in as opposed to, a federal district court settlement. Sometimes there's less attention paid. I don't believe that based on the reading of the case that it's going to affect settlements, even settlements with fraud charges and large civil monetary penalties, because they are agreed upon. But I would expect the SEC, if they haven't already, to be changing some of that waiver language that's in the offer of settlement that respondents sign. So saying that you explicitly waive your right to a trial by jury. But otherwise, I would expect, and I certainly, as a defense attorney, hope that administrative proceedings are still, an open forum for SEC settlements, regardless of the charge. The one other kind of question mark that'll be interesting to see how the SEC handles it is there are many cases the SEC brings that do not include fraud charges. So technical violations, failure to register, whether failure to maintain adequate controls and procedures, other cases where there's no fraud allegation, but there is oftentimes a civil monetary penalty. I would expect those to also be done in federal district court, but it'll be interesting to see how the SEC decides to apply JARCISI to their own internal forum decision making. And with that, I'm going to turn it over to Mr. Bill Sherman to talk about some of the effects in the energy world.
Thank you, Rebecca. And Ron and Rebecca have covered the basic holdings of the JARCISI opinion. So I will just try to briefly talk about the impacts on FERC. The FERC got civil penalty authority of any significant magnitude for the first time in 2005. So its jurisprudence on civil penalties is a lot more recent than dating back to the original SEC organic statutes. But what is very clear about the FERC civil penalty authority that Congress gave them in 2005, it is modeled extensively and explicitly on the SEC statutes that were at issue in JARCISI. So the important thing to take away from this is that when FERC brings an enforcement action against the target and seeks a civil penalty for a common law type fraud claim, including market manipulation, fraud, misrepresentation, those will need now to be brought in federal district court. Justice Sotomayor in her dissent explicitly listed FERC as one of the administrative agencies that would be affected by the JARCISI opinion. Unlike the SEC that largely had abandoned trying to impose civil penalties in ALJ proceedings, FERC never got that message or that memo from the SEC, and FERC has steadfastly attempted to use in-house ALJs in enforcement cases since 2005. Now, presumptively, respondents to FERC enforcement actions where FERC is seeking civil penalties under the Natural Gas Act and the Federal Power Act will have the right to a jury trial, which is only afforded in federal district court. It is very important that the ramifications of this are understood. And let's go to the next slide, if we could. And you'll see here where FERC has explicitly acknowledged in both their prohibition on energy market manipulation statement and its enforcement policy statement, FERC has said explicitly that it is modeled on, its authority is modeled on the SEC's. It's going to look to SEC precedent to interpret its own statutory authority. It's going to look at additional SEC decisions and case law when acting under its new authority. FERC has steadfastly and deliberately tried to keep its cases inside the ALJs because, with one exception, FERC enforcement has won every single case ever brought under this 2005 authority. Every single case but one, FERC has won. So you can understand why FERC has always wanted to have a home court advantage in bringing civil penalties cases to their own ALJs. And the Chief Justice, at the very end of his ruling in JARCISI, explained, as both Ron and Rebecca have discussed, why that is so important. FERC has been very clear that in civil penalty cases before their own ALJs, that ALJs are not required to apply the federal rules of evidence. ALJs are not required to apply the federal rules of civil procedures. The discovery rights of defendants are much more curtailed before FERC ALJs. And so the fact that now we can have these fights on a much more even playing field in federal district courts with the right to a jury trial is really quite important. And just to make sure there's no misunderstanding, if we'll go forward another page, here's the side-by-side that shows the FERC civil penalty language, FERC market manipulation language, and the SEC's language. And you can see that in drafting the 2005 Civil Penalty Authority, the Congress lifted whole cloth sections out of Section 10B of the Securities and Exchange Act of 1934. So I think the argument that FERC staff, especially FERC enforcement staff, has continued to make that they're entitled to bring these cases before a home court ALJ is all but been laid to waste by the Jarkissi opinion. That's not to say that I would expect the FERC enforcement staff to lay down and not try to shoehorn some of their cases into the public rights exception. But I think, as Ron Tempest said a few minutes ago, the public rights exception is now truly an exception to be narrowly construed because, as the Chief Justice said, the presumption now in civil penalty cases where the FERC is seeking civil penalty authority as a remedy is the presumption. It's the other last thing to note on this that's very important is prior to 2005, FERC had extraordinarily limited penalty authority. FERC almost never used that penalty authority because it was extremely narrow and cabined to particular kinds of cases. So FERC really doesn't have another vehicle to assess civil penalties other than its 2005 statute, and now those will be brought in federal district court for the most part, unless FERC tries to somehow, as I say, shoehorn its enforcement cases into the public rights exception. Let's go to the next slide. I want to just talk real briefly before I end about the Chevron decision and what that means at FERC. And what you have on the screen right now is dueling statements last week from FERC Commissioner Mark Christie and FERC Chairman Phillips about the impact of the Chevron decision on FERC's recent transmission planning and cost allocation rulemaking, order number 1920. You'll see here that Commissioner Christie has said very clearly that he thinks from the very outset that order number 1920 was unlawful under the major questions doctrine. And now he thinks that in light of Chevron, one of the pillars of the Commission's statutory authority to move forward under order 1920 has been removed. And then you see on the right side of the page, the Chairman Phillips saying nothing in the Chevron ruling pulls out or undermines the Commission's authority to act under the Federal Power Act over the transmission rules that the Commission has now put in place. So that will obviously play out here over the next couple of months. We now have 3 new members of FERC, and so the Commission has turned over. I'll conclude by also just mentioning that Chevron will also have an impact on FERC enforcement cases that will now be heard in federal district court. Some of you may recall several years ago, the Fifth Circuit overturned an in-house FERC enforcement ruling that applied the Natural Gas Act market manipulation to certain trading activities of a major trading shop on the grounds that the FERC had improperly expanded the definition of the in connection with language that's found in both the SEC, FERC, FPA, and NGA language, and said very clearly that FERC had exceeded its authority in using the in connection with language to try to untether from its traditional Federal Power Act or Natural Gas Act authority transactions that are subject to FERC enforcement. That was done by the Fifth Circuit. It was never appealed by FERC. Those are the kinds of rulings now that will also be subject to Chevron, where FERC will be required to come up with the best interpretation. And the courts have now made clear that the in connection with authority that's contained in the Gas Act and the Power Act cannot expand the organic authority that Congress gave FERC to begin with in both the Federal Power Act and the Natural Gas Act. So Chevron will have an impact both in the transmission policy space, and it will also have an impact in the enforcement space. So with that, I think I'm supposed to turn it back over to Jeremy or Ron. I'm not sure, but that's all I've got to say about FERC for now.
Fantastic. Thank you so
Jeremy,
much.
one last thing.
Yeah.
We're going to talk a lot more about these issues at the second annual V&E Vincent and Elkins Energy Conference in Houston in late November of this year, right after the election, where we hope we'll spend the better part of a day, day and a half talking about what the outcome of the election means for the energy industry. Sorry, Jeremy, I wanted to get that shameless plug in before I forgot.
Perfect. So we had some great questions in the chat. We won't have time to get to all of them, but two were kind of cross-cutting that we did want to try to respond to. The first was, what was the impact of Loper Bright on agency guidance and other kinds of agency promulgations that have never been entitled to Chevron deference? And I think it's a great question. The answer is probably not that much, because those kinds of interpretations didn't get deference anyway. And as we think about how much Loper matters, it won't matter that much where Chevron didn't apply. And there's a whole section of doctrine about where it didn't apply. But I think folks have already started to wonder, there are different forms of deference, including one called Auer deference or Kaiser deference, that apply to an agency's interpretation, for instance, of its own regulations. Whether Loper portends a willingness of the Supreme Court to revisit and cut back on those forms of deference, I think is something to watch over the coming years. So we have maybe just time for one final question and answer, and this will be for Ron. The question was, what impact of JARCASI on state administrative agencies, given that JARCASI was grounded in the Seventh Amendment? So do we think we'll see changes or impacts for state enforcement proceedings at the state level?
Yeah, so thanks, Jeremy. 4 quick points on that. Start with the kind of nerdy lawyer point. The Seventh Amendment, unlike other constitutional provisions, has never been, as they say, incorporated, i.e. it's never been held to apply to the states in the way that some other constitutional provisions, like you got to have a search warrant before you come busting into my house, has been applied to state and local police agencies. So formally, it has no controlling effect. Having said that, a couple of things. One, an awful lot of state constitutions will have similar provisions. And a decision like this may get people kind of focused on, okay, even if JARCASI doesn't control, now if it's a state administrative agency, does my own state constitution give me some right to a jury trial instead of an administrative proceeding? And JARCASI's reasoning may be persuasive on that question, as well as just flagging that as an argument. I suppose it might reinvigorate people wanting to argue for incorporation of the Seventh Amendment, because now there is, it means more, so to speak, if the Seventh Amendment applies to state agencies. And then the last point, I guess I would say, there are some areas, environmental is an example, where you have this notion of cooperative federalism, and sometimes the state agencies are essentially acting pursuant to or carrying out authority they've been given under a federal statute, like the Clean Water Act, Clean Air Act. In that context, I think, frankly, I'm not sure. It seems to me it's going to be a complicated question, but I think there's probably going to be some pretty serious arguments that, since the state is in effect standing almost in the shoes of the federal agency, such as the EPA, that the Seventh Amendment is going to apply. But I got to say, that's a kind of speculative sort of guess on my part as to how that plays out.
Excellent. Thanks, Ron. So I think we're right at 90 minutes. I want to thank everybody for hanging with us. As I said, please feel free, if we didn't get to your question, to reach out to the relevant person. You can see the bios on the screen. And we've had great discussion, landmark decisions, but a lot yet to come. So please keep an eye out. We will likely be having issue-specific or area-specific follow-on sessions. Watch your emails for that, and please feel free to tune in if they're of interest. And thanks again to everybody for joining.